Mr. Justice Muhammad Imam Ali, Honorable Judge of the Appellate Division of the Supreme Court of Bangladesh. Mr. Justice Muhammad Imam Ali.
বিসমিল্লাহিররহমানিররহিম। মাতৃভাষার মাস ফেব্রুয়ারি মাস, বিনম্র চিত্তে শ্রদ্ধা জানাই সকল ভাষা সৈনিকদের, তাদের আত্মার মাগফিরাত আমরা কামনা করি এবং তাদের বদৌলতে আমি বলবো যে আজকে আমরা বাংলাদেশ পেয়েছি। Although it is the month of mother language, I would like to speak in English, if you will permit me. And first of all, I don't know whether Tanushree is in the audience, but on my own behalf and on behalf of all of us here present today, I would like to congratulate her on being enrolled as an advocate of the Delhi Bar Council. Next, I would like to thank wholeheartedly Bangladesh International Mediation Society for inviting me this evening to be the chief guest in this very timely seminar on mediation. The former Minister of Law, Justice and Parliamentary Affairs, Mr. Mutin Khosru, is present in our midst. He is also a member of the Cabinet Committee relating to law and justice. I would draw his kind attention to the fact that we do not have a law on mediation in our country, and I believe it is high time that we did have a law. Mr. Goswami and Mr. Kundu have given us their views with regard to mediation being the best form of ADR, alternative dispute resolution. And I agree with them. And I will tell you briefly why I agree with them. Now, before that, I would like to give you some facts and figures. As on 31st December 2019, there were 489,068 cases pending in the High Court Division of the Supreme Court of Bangladesh. In the Appellate Division, there are 23,617 cases pending. That together makes 500,000 cases, more or less. As on September 30th, 2019, there were 3,127,243 cases pending in our lower courts. So altogether, we have more than 3.5 million cases pending. That, in my opinion, is the best reason for all of us to turn to alternative dispute resolution. We all know the adage, justice delayed is justice denied. And with 3.5 million cases pending, justice is bound to be delayed. We have cases in our system which go back to before 1970. We have to find ways of dealing with this backlog, and we have to find ways of doing and disposing cases more quickly. As you have heard, there are a number of ways of dealing with cases: the alternative dispute resolution, negotiation, mediation, conciliation, arbitration. Having dealt with a number of cases relating to arbitration, I would suggest that that is not really the best of the modes of dispute resolution. Because by now, arbitration has become too time-consuming and also quite expensive. The idea behind arbitration was to ensure quick disposal of cases, and also cheaply. But as time has gone on, arbitration has become more and more technical, and the arbitrators, the time consumed, all amounts to lots more of expenditure than was anticipated. Conciliation, mediation, and negotiation. Negotiation, of course, is the best way to deal with things, simply because the two parties who feel aggrieved by each other's actions negotiate among themselves and decide to give and take. One thing that is very important to be remembered is that alternative dispute resolution means give and take. You cannot say, I accept the mode of mediation or arbitration, but then I do not accept the finding, this is my right, this is my property. You cannot go on and keep on saying that. There is a point when you have to give way and say, well, yes, to break even. Think of the cost that you would incur in continuing the litigation. To cut your losses is the best policy. Mediation is voluntary, it's informal, it's impartial, and most of all, it is confidential. You all know that Section 89 has been amended in our Code of Civil Procedure to incorporate mediation. And the drawback, unfortunately, is that if the mediation fails, then that court cannot any longer continue with that trial. It has to go to another court, another judge, in order to complete the trial, and we all start afresh. The mediation has to be totally forgotten. Anything said, mentioned, any evidence produced in the mediation will have to be forgotten and left out of consideration. So if the mediation fails, then unfortunately, we again go back to square one and we gain nothing. But then on the other hand, if mediation succeeds, then, as has been said already, it is a win-win situation. Both parties decide the mediation, what they will accept, what they will not accept. The mediator's function is not to decide or is not to dictate how the mediation takes place or what the award is to be or how much each person is to get. The mediator effectively is just a referee, and he is to initiate the negotiation between the two parties. Nowadays, we also have judge-based mediation, which allows, in fact, the judge to point out the strengths of any particular party. In a way, that I suggest is good, because then the parties realize, or are made to realize by someone in authority, the judge, who will tell them that the law is this, and you do not stand to gain anything to continue on this line of argument. And this is where the parties will decide to give and take. This is where the parties will be told that plugging this line is not good, it will not help you. So they go on a different calculation. Mediation is speedy, because once the action, the litigation, goes to mediation, then it is entirely up to the parties to conclude the issues between them. And once it is concluded, it is finished once and for all. We find that in many cases where litigation takes place in the courts, an acrimony develops between the parties. It goes on through the generations. The enmity passes on from one generation to the next. Whereas with regard to mediation, once it is finalized, then there is no more acrimony. Because both parties have agreed that this is our solution. And therefore, the whole matter comes to an end, and within the shortest possible time, because once both parties agree to go to mediation, then both parties effectively decide that we will finish this as quickly as possible. And I'm sorry to have to say this, but in mediation, there is effectively no involvement of lawyers. And that perhaps may be a good thing. The lawyers may not like me for saying so, but sadly I have to say that the lawyers, very often we find, do not help their clients for their own benefit. I remember a time, probably about 15, 16 years ago, when I was in Chittagong, and some of my colleagues of the High Court Division at that time were presenting some work on arbitration. And they were finding it very difficult to convince the lawyers to indulge in the practice of arbitration, taking matters to arbitration. And the reason at that time particularly was that the lawyers thought, if the case is decided and finished, then our case is gone, our income has come to an end. So my colleagues asked me to say a few words. And the way I put it in that meeting was that learned advocates, have confidence in yourselves. If you can show to the public that you are good at disposing cases quickly and cheaply, you will soon become a very popular advocate. And you will be disposing of your cases so quickly, and more cases will be coming your way, and you will be the winner at the end of the day. So I have to say that again. Arbitration, mediation. In arbitration, of course, there are involvement of lawyers, but if the arbitration takes place properly as it should, then it will finish quickly, that is true. But then, as I said, if you can finish your cases quickly, you develop a reputation of being a good lawyer who can deliver justice quick and therefore more cheaply. Mediation is, of course, far better. It is cheaper and it is more quick. So, to that extent, mediation is better, but only if the learned advocates will cooperate with the system. We have laws now. The CPC, for example, provides for mediation. The Arbitration Act provides, even the Arbitration Act allows for parties to decide to go for mediation. So that is an indication in my mind that mediation is probably a better way of dispute resolution. Because the Arbitration Act provides that even during arbitration, the parties may decide to go for mediation. Obviously, that means that mediation is a better choice if the parties agree and decide. Also, the Order in Adalat Ain has provision for mediation. Now, all this is only going to be of use if the people are aware that mediation is a better way of dealing with litigation. We have the Gram Adalat. That is the best place to end litigation at the grassroots level, because your neighbor then becomes your friend, because there is no dispute between you. But unfortunately, the Gram Adalat, as it has developed, has perhaps become less independent than it was before, because the persons now presiding the Gram Adalat are persons affiliated to particular political parties, And as a result, the people litigating public feel that they may not be getting the favors of the particular presiding Gram Adalat because they belong to a different party or because they voted for somebody else. That is a sad aspect. I believe that if the local administration was more independent and less political based, then the Gram Adalat would be more effective way of dispute resolution. Our Honorable Chief Guest is Honorable Excellency from the Indian High Commission is here, so I don't want to extend too much more time. Just to say that I believe mediation is probably the better of the dispute resolutions that we have in our country. It is in our law, but finally I would like to say that we do need a law, a specific law on mediation, supported by rules on mediation, in order for the scheme to be effective and beneficial to the public. And with those words, I thank you all very much again for your patient hearing, and thank the organizers for inviting me. Thank you.